Thank you for my introduction. Yes, I'm a fellow at St Edmund's College in Cambridge. I teach intellectual property there at the university. I was mentioning earlier on, I also teach the law of ancient Rome, but that's a session, that's a different session you might come to. So, intellectual property. Yes, I've been very fortunate. I've had a background in plant breeding, genetics, as well as law and intellectual property. I worked for Shell for a few years when they set up a biotechnology division, and as a result of that, I was sent off to Cambridge for a sabbatical. I got a degree in plant genetics. I was lucky enough to study IP at university and worked in Shell as a manager, as a lawyer, working in IP transactions. My PhD is in knowledge transfer, as Hilda said. So I work in the field of, my research was in the field of how knowledge transfers from academic institutions into industry, the awareness of scientists, their relationships with industry, what industry is expecting, what they demand, and the nature of the relationship and how knowledge flows. So I did that at Imperial College a few years ago, and since then I've worked for a number of centres. Currently I work for ICRAF and SIP, as well as IITA, but I've also worked in ICRASAT and ICADA and CIMAT and CIAT and a few others. So it's been a great pleasure working probably for the last 8 or 9 years in the CGR involved in intellectual property. And when I say intellectual property, I mean both the idea of ownership or the idea of creating knowledge, but I mean it also in the sense of strategic. And I think in a way, from the CGIAR Centre's point of view, it is the strategic aspects of intellectual property that are as important. And if you like, in one way, the strategy of the CGIAR Centres in terms of IP is the public domain. In other words, or global public goods, if you like. In other words, we make our knowledge freely available. We make it widely available to anyone who wants it. And I think that has a lot of advantages. It's a very appealing way of doing things. It ensures that at least people get access to things, get access to germplasm and access to our know-how. Equally, as a strategy, I think it has limits. And as you're aware, some centres are engaging increasingly with the private sector, with companies with whom they want to make some transaction that perhaps doesn't open up their knowledge to everybody. And I think that's a recognition and an awareness that sometimes you do need to control your intellectual property, not in order to get revenue, but to control it in order to encourage one or more commercial partners to work with you, to have the advantage of working with you. Yes, traditionally companies want exclusivity. But the reason they want exclusivity is because that way they know they're the only people with the right. An exclusive license to a variety, say. An exclusive grant of plant variety rights. That means the company you've licensed to is the sole beneficiary, recipient of the variety. They're the only ones who can commercialize it. And therefore, of course, in turn, it justifies their risk of investment in commercialization. It justifies them bulking up seed, it justifies them marketing it, it justifies them creating a market among farmers and then selling the seed, because the exclusivity that they've got through the intellectual property license enables them to be confident that they will have something to sell and won't be competing with that variety with other seed companies. So I think intellectual property strategy is something which, in my own view, is important for scientists in particular in centres to reflect on. I think in many cases the public domain is the best way of dealing with the knowledge we produce. But I think there will be situations where something more controlled may be more appropriate. And the point about intellectual property is that what it does is it grants rights in knowledge. It grants a monopoly in knowledge. I think the other thing I would say is that
Most of what we do is about producing knowledge, is about germplasm, varieties, agricultural, agronomic know-how, in order to improve the quality of life of smallholder farmers in developing countries. That's what we're here for. That's what all the centres are doing. And I think, therefore, that intellectual property should simply be seen as a peripheral part of that. It is simply an aspect of it. And it's an aspect which should be considered in terms of how successful are we at making sure that our research is adopted, is taken up. Is public domain the best way, or are there other more specific routes that we could take? But I think the main point is that it's the knowledge we're producing that is most important. So I wouldn't like people to think that I'm proposing more importance for intellectual property than I believe it has. It is simply part of the delivery process. It's quite an important part of the delivery, but it's simply a part of that whole process. But as I think all of us are aware, donors are increasingly interested in impact, and the way we manage intellectual property, the way you control it and distribute it, obviously can have a significant effect on impact. So I'm going to pull back a little bit now and just run you through some of the basic notions in intellectual property, both in terms of the nature of IP and also in terms of the sort of transactions where you're coming across IP. Obviously some of this will be familiar to many of you, so sort of bear with me as we run through it. Okay, so intellectual property is a recognition, if you like, of people's knowledge inventions, the things they've created. And so rather like real property or personal property, you own a car, you own a book, you own a piece of land, what intellectual property does is to give recognition to the rights of your invention, of your ideas. And as you see, we grant intellectual property rights in all sorts of cases, so filmmakers, musicians, authors, poets, chemists, engineers, plant breeders. But intellectual property is a social creation. In other words, it's simply a set of rules which various governments have decided one should have. So the limits of intellectual property are entirely defined by the state, by the government. It's a matter of the law. And therefore there are some areas which are simply not protected by IP or not protected very well. I don't know about here in Nigeria, but in other countries, in some countries, particularly the US, there's a lot of debate about ownership of films and distribution of films across the internet, and that's a challenge to intellectual property. You're the owner of a film, you want to get, you spent money having it made, you want to get revenue back to pay your costs, to make a profit. And you do that through cinemas, through selling DVDs, through licensing it to television channels. But if people get hold of a copy and distribute it on the internet, or if there's a website where you can watch a film for nothing, that means the intellectual property rights have been, if you like, challenged or avoided, and therefore the filmmaker simply doesn't get revenue. So it can have an enormous effect on the economic process. Intellectual property usually needs certain standards of creativity. In other words, generally we require some level of inventiveness. It depends, not all of them, but copyright doesn't particularly. Plant breeders' rights certainly do. Engineering, chemistry, we have certain principles about how a right should be granted, how inventive you have to be, how novel your invention in order to get rights. At the same time, the rights you get are limited by time and by country. Most rights are national, so you don't have a patent, you have a patent in a particular country. So it could be that one would take out intellectual property rights in a certain country. because that's where you believe there's a good reason for doing so, and leave the information in the public domain elsewhere. And of course, they only run for a finite number of years. The usual reason for taking out intellectual property is either to create a monopoly, in other words, to keep something for yourself, or to exploit it commercially by licensing. So if you develop a piece of engineering that can be used, say, in a, I don't know, little thing like this, you develop some engineering that goes in here, you've got a choice. If you take a patent out on it, and you can probably get a patent for something clever in here. If you take a patent out on it and you're the owner of it, it means that you've got a choice. You can either manufacture these yourselves. So you become the manufacturer and you sell them. And you can sell them at a premium because other people are stopped from producing the same thing. Or you might decide that you're not a manufacturer and it's better to license to others. Or perhaps you're only operating in certain countries. So you would license the knowledge, the patent in here to other manufacturers, and they would pay you a royalty. So the point is that intellectual property is almost intrinsically about commercial activity. It's about making money. And I think that's probably one of the reasons why within the CG centres we have a reluctance to get involved, because that's not why we're doing it. I think there's a reluctance because, well, we're not looking to get revenue, we're not looking to create a monopoly. And I think the answer to that is, that's absolutely right, we're not. However, we can use intellectual property for other things, not least of which is we can stop someone else patenting or protecting know-how we have developed. And if you do decide to license, well, yes, you can. The license is simply consent, is approving someone taking out rights. And yes, it's often for a royalty, but it doesn't have to be. I was doing some work with ICRASAT in Kenya recently, and we're working on or at least I'm proposing an intellectual property strategy there, where we will take out plant variety rights in one or two varieties. We will then license those PVR, those intellectual property rights, to a small group of seed companies, and in return, we're not looking for revenue from the seed companies, but in return we will impose conditions on them in terms of availability of seed to smallholder farmers, so small sales, and we will impose conditions of the quality of the seed, germination, and the trueness to type. So we can impose those obligations on the seed companies through our plant variety rights ownership. So that would be an interesting example, I think, of where we're using intellectual property and the rights it gives us, not to get money back from licensees, but to create other circumstances which are valuable and important. And then, yes, the final point, of course, is that plant variety protection, PVR, is the one that applies for plant varieties. So, yes, the main ones, we've touched on some of them. Patents. Many people are probably familiar with patents. Patents are about quite a lot of areas: engineering, chemistry, biotechnology, of course, it's particularly important, genetic engineering. All of these areas one would find patents, and I think it probably has quite a sort of commercial ring to it. Copyright, newspapers, magazines, television programs, films, all of those will be protected by copyright, books and so on. Those are protected by copyright, and basically it's designed to stop you selling a copy, stop you buying a copy of a book and simply photocopying it and clipping it together, or buying one copy of a film and then making multiple copies. Trademarks, you see trademarks around a lot. They're the names and the logos on top of shops and companies and airlines and all sorts of things. And the trademark is the notion that this is my brand, this is my identity. I am, BP or Shell or McDonald's or whatever, or British Airways. This is my brand name, and I want to get intellectual property rights on it because I want to stop other people claiming that they are me. I want to stop other people claiming that they can use my brand name, and the trademark is a mechanism for doing that. Plant variety rights, some of you I'm sure are familiar with, developed quite recently. PVR only started through the UPOV Convention in 1961, which basically set down the framework for plant variety rights. And since then, I think there's about 85 countries are now members of UPOV and apply the basic principles of PVR. And then, of course, confidentiality, simply not telling people. It is an aspect, it is a form of intellectual property. So I'm just going to run through these quite briefly, I think, just so we've got a sort of sense of them. The exclusive right to make, use and sell, a rather perhaps pedantic expression. What it means is, if someone comes to you and says, well, we've got this DNA library, or we've got this gene, which we have protected by patent, and therefore we're willing to license it to you, but in return for some reward or in return for access to germplasm. And the reason they can say that is because they have the exclusive right to make, use or sell. So the exclusive right over what you can do with it. Now, of course, bear in mind, as I said a few minutes ago, intellectual property, of course, is national. So if someone comes and says, well, I've got a patent, do you want to take a license? The obvious question is, well, where have you got a patent? Got one here? Got one in Nigeria where we want to work? Have you got it in a country where we want to use that gene? Because if the answer is no, then you don't need their consent. So having a patent in one country doesn't, of course, give you any rights in another. So that the rights granted, the exclusive right to make, use and sell, is a national thing. And yes, tests of novelty, inventive step, industrial applicability. So novelty, is it, has this already been described? Have we already released this? That's why if there are issues in IP or interest perhaps in taking out patent protection, perhaps in the biotech area, then if the information has been disclosed, perhaps presented at a conference or a workshop, or just made available to colleagues, perhaps somewhere else, if it has been disclosed, then that will probably mean that it is no longer patentable, because it will fail the test of novelty. So it means if there is an interest in patent potential, then you need to be quite careful about publication, almost in any form. It's only really protected where you're making the information available under confidentiality. Inventive step. Is it inventive? Is this something that people really hadn't thought of before? They hadn't thought about, they hadn't, this wasn't an obvious thing. This is really quite clever. And all sorts of case law on what quite clever means, but essentially, has someone invented something that's new and different from what's gone before, and not simply obvious? So there is a hurdle to getting a right. And then industrial applicability. Interestingly enough, this has actually come up in biotechnology and genetics for the last few years, where companies have tried to protect simply sequences of DNA and claim a patent over it. And that's often been rejected now by courts and patent offices, if they don't know what they're for or what they do. As I said, they're national and by country. They're very rare in centres. I use the word rare because I don't think I've come across any. So perhaps they're very rare, but there's a chance. Copyright, this is the sort of area, as I said a little while ago, is to do with writing, publications, websites, photographs. So if you take a photograph and perhaps put it in an article, or perhaps put it on the centre website, that's copyright of you or of IITA. So if someone wants to use it, they would have to come and obtain consent from you. Similarly, if you see a chart or a table or a photograph in someone else's publication that you'd like to use, that copyright belongs to them, and so you'd need to obtain consent. As I say, it applies to all these sorts of things: information, charts, diagrams, photographs, plus of course text. And it's not likely to be an issue, but I've come across situations where companies have, used perhaps data that we produced in a centre and published it without permission. And it's a problem, because not necessarily we're looking to make money, but if donors' money and work in a centre has created that chart, we want recognition. We want to exercise our copyright rights to ensure that the person who publishes it puts a recognition saying, this work was done by such and such a centre, and acknowledging it. So if you like, again, you're using intellectual property rights through copyright to make sure, to ensure that the centre gets the recognition for its work and its output, not necessarily looking for money. And this, it's exclusive right to control. So, as I say, we do have a lot of copyright. We do normally allow anyone to use it. I don't think I've come across situations where we look for financial return, but we are looking for recognition of authorship. So again, a fairly simple process, but just ensuring we get proper credit for it. Trademarks. Quite a lot of centres have trademarks, usually to protect your logo, your name. Why? Because you don't want perhaps a company saying, support from IITA, or we work closely with IITA, because at that point they're using your logo, and therefore they're claiming a relationship which perhaps doesn't exist. So it is trademarks that you would use as the basis for stopping that happening or regulating the use of it. Companies are often extremely cautious about the use of their trademark, because of course trademarks, we're used to brands, we're used to logos and names, and trademarks therefore can create a sense of attribution. So yes, I tend to come across trademarks in centres, usually, as I say, protecting your names and logos. Whether it's worthwhile, I truly don't know. I'm not convinced it's a good use of money, because I think that there are other mechanisms to deal with someone who wants to make use of a centre logo. And of course the trademark is national. So the question is, well, okay, where do we take a trademark out? Where do we go and get protection? Which countries? Because of course, bear in mind that trademarks are a legal mechanism. So you take out a trademark, it means you have to be alert to people copying and misusing, and then you have to go and enforce it. So you need to make sure that the legal system within the country is also sufficiently efficient to enable enforcement to take place. So I think it's quite, I'm not entirely convinced that it's worthwhile. Plant variety rights, perhaps the sort of, if you like, classic for the CG, or one of the classic IPs. Again, very few centres do actually have plant variety rights. As I talked about a minute ago, I personally think that PVR is something we should think about using, where centres produce varieties as a mechanism for ensuring that the varieties we produce are distributed, disseminated in ways that we regard as positive. And so I think things like exclusive licenses should be part of the IP strategy in relation to plant varieties, both in terms, as I say, of ensuring perhaps that merchants apply the principles that we want, but also to avoid other people gaining the credit for the work that perhaps has been done here. I'm sure you're all familiar with the test, the US, distinctness, uniformity, stability. Distinct, is this variety clearly different from what's gone before? Is a plot of this variety got consistent characteristics, usually morphological characteristics, and therefore can be distinguished? Is it uniform? So if you plant it generation after generation, will it keep growing that way and look much the same? Stability, looking much the same generation to generation, and uniformity is the entire crop looking like that. The limit to intellectual property plant variety rights, of course, is that it applies only to breeding material. It doesn't apply to consumption material. So it does have limits and constraints. I say there are a few PVRs, but not very many. And then confidentiality, perhaps the least relevant for centres, because it's perhaps the sort of IP that would most conflict and contradict what we're here for, which is dissemination. Although interestingly enough, I suspect we go in for de facto confidentiality, perhaps more than we'd like to believe. And de facto confidentiality is where we simply don't make information available. And of course it's something which is coming up at the moment with increased interest widely, globally, in public access, in access to information, open access, a phrase you may have come across. And the consortium office at the moment, in conjunction with centres, is actually exploring ways that the centres can make their information more widely available. But not just the publishing information, it's the data that underpins it. So raw data that's being collected. And I think there is, certainly from my experience of a number of centres, there is a lot of raw data that is simply physically not made available. So it's not that we overtly keep it confidential, it's that we just don't have it in a form that is accessible to people outside the centre. And this, I hasten to say, for all sorts of good reasons, difficulty of processing, IT issues, interrogatability and all those things. So for quite important and sensible reasons. But I think we're going to see a situation where centres are increasingly going to be expected to make all their data available and to hold back what they don't want to. A few transactions, I guess you'll have come across some of them, which are about managing your IP. I think we've touched on probably most of these. Contract research, you might do a little bit here. A few centres do a little of this. Contract research is essentially where someone asks you to do a piece of work, produce some new knowledge, test something, and then hand over the results. And the IP in contract research usually belongs to the person paying. And it's usually, please test this agrochemical, please trial this variety, please evaluate this this trait or characteristic. And that would be contract research, so in a way that's quite locked into IP. Collaborations agreement, much more likely, public and private, so collaboration, say, probably the most familiar, where again the issues are, well, how do you share the IP that's being created? Who does the knowledge belong to? If you're doing it jointly with 5, 10 or 20 or 30 partners in a collaboration. But those things do create IP, and therefore one needs to know, well, who owns it? Who owns the results? I probably own the results that I did, but what about results that were the result of joint or collaborative activity? Licenses we've touched on, where you'd exercise your rights over IP. MTAs, mutually transferable. God, sorry. Material transfer agreements. I don't know how that got through. Do please cross that out. Yeah, MTAs. That is embarrassing. I'm sorry. I hope we're going to take that bit out of the film and change it. Put the other slide on. I'll stand in front of it. MTAs. Yeah, I'm sure there's one you're most familiar with, where you're sending out material or receiving material, and the person who sends it to you accompanies it with an MTA. MTAs are usually quite specific in their content, in the sense that they are usually saying, well, the person sending it to you owns it, and it's being sent to you personally. You can't share it with anyone else. You can't use it on anything else except the specified project. You certainly can't give it to another institution, and at the end of the project you have to destroy it. And any results, interesting results, you probably have to share back with the person who supplied it to you. So MTAs are quite a useful document. Some of you will be familiar with the SMTA, the Standard Material Transfer Agreement, which is quite a benign document, but very, very similar. The only thing to point out, I think, with MTAs is be aware, because sometimes people do try and sneak other clauses into MTAs. So it looks quite nice, and then somewhere down the bottom you'll see a clause which says, and any inventions made using our material belongs to us. So it's known as a reach-through clause. So you do need to be slightly careful on MTAs. And then confidentiality. Again, it's an aspect which probably some of you have come across, maybe working with a company that's willing to let you use some information they've got, but not willing to let you make it more widely available. So again, it's about exercising their rights over their IP to make sure it stays in control. Also, of course, going back to patents earlier on, if you send someone information under a confidentiality agreement, then that means you haven't harmed any potential for getting a patent. And then finally, I think, why is it important? I think we've touched on some of these, but I just want to sort of pull them together. I think the first thing to say is that intellectual property for many organizations is about exploitation, is about commercialization. But it is important for centres as well, even though that's not what we're doing. We need to be aware of IP, partly because other people are. Many of the people you work with, probably not donors, but certainly companies, are aware of their IP and are aware of its value. And their role, one of their objectives is to own, acquire, develop, and control IP. That's what they want to do. And in transactions, they're going to play quite hard. You know, it's not their job to be nice. They may want to be nice, and they may be nice at appropriate moments, but in general, their job is to get hold of as many intellectual property rights as they can. So we do need to be very alert to those things. We need to be alert because we have to deliver on our mission. And transactions which prevent us doing things like that, transactions which in some way lose us IP rights or give rights to someone else unwittingly, are very important. Sometimes, as I said, we can use IP, can deliver on our mission by using IP ourselves. We use plant variety rights to license to growers. We use confidentiality agreements to ensure that work done here is recognized here. We use, say, a copyright to make sure that we get proper recognition in a publication. So a lot of IP transactions and rights are simply about delivering on the mission, about enabling us to do so and not stopping us. Certainly, of course, IP can provide public access. You know, the public domain is an IP strategy. You know, it is a perfectly proper and respectable IP strategy, but you have to look after it. To put it plainly, if you enter into a collaboration and the collaboration says the results of this research cannot be put into the public domain, cannot be released outside the participants, then we can't put it in the public domain and we are failing to deliver on the mission. So that will be a situation where the IP is being used against us to stop us freely releasing. And at the same point, the idea of sharing research results. We need to be aware of the IP elements of the transactions we're making in order for us to share. And then finally, and I'm putting it very finally, compliance with the IITA principles. Some of you may be aware of these. This is a document that was prepared by the consortium office and agreed to by all the centres, and does put some obligations on centres in terms of management of IP. It puts quite a lot of obligations on Hilda and Lucy in terms of management of IP. We have to report to the consortium office annually. You have to report to your own board here that we're running IP and managing IP properly, and that statement has to go to the consortium office. So part of the IITA principles is to ensure that centres are looking after things properly, that we know what we've got, that contracts are analysed before they're signed, that we're signing off on things to know that the IP clauses are acceptable and consistent with what IITA should be doing. So part of it, if you like, is what you might call good housekeeping, but there are also some obligations about when we can enter into contracts with exclusivity and so on. Not particularly onerous, really not particularly onerous, but onerous except in terms of process. We can do whatever transaction we like, however much exclusivity you want, but you have to justify it, and you have to be able to set down those justifications in a formal document. So in a way, I think the IA principles are sort of, I was going to say annoying, but since this is being recorded, I won't say annoying. They are they're a document which we ought to comply with, and if we're running and looking after IP properly, they will not be a problem. They will not provide us with any further obligations, particularly. So, if you like, I think they could be viewed quite properly as a part of the process of managing IP, and I think if centres are doing that, they shouldn't find the IA principles at all a problem for them. I think what it's doing is encouraging centres to be aware. Anyway, and there we go. Thank you very much.